Hello class. In this video we will be recapping what we learned concerning Section 2040. Property included under Section 2040 is reported on the Schedule E of Form 706 and is used for any property that is pulled in under Section 2040. Section 2040 provides us with three different rules of inclusion for interest relating to joint tenancies, tenancy by entirety, and joint bank accounts. So I'm going to give you a number of illustrations that will help you determine how these rules work. So with respect to Rule 1, if the joint tenancy exists between spouses only, and in this case you have H, which is the husband, W, who's the wife, then the rule that applies is found in Section 2040B. And in this case, we would include 1/2 of the value of the property in the decedent's gross estate. And this is referred to as a spousal joint tenancy. Under Rule 1A, if the joint tenancy is between or among someone who is not a spouse, then it's referred to as a non-spousal joint tenancy. And in this case, we have H, who's the husband, W, who's wife, and C, who is obviously a non-spouse. Well, because someone other than a spouse has to be a joint tenant, again, because there's three parties, we cannot obviously have a spousal joint tenancy, and so it's referred to as a non-spousal joint tenancy, and it's governed by Code Section 2040A versus 2040B. Under Rule 2, it's going to relate to non-spousal joint tenancies that are acquired by gift. Gift, device, or inheritance. And so in this situation, we have G, who has gifted property to H, W, and C, neither of whom have provided consideration. And when one of the joint tenants die, and in this case we're saying H died, that joint tenant receives a fractional share of the property. So that fractional share is the value of the whole property owned by H, and it's included in H's gross estate. So 1/3 of H's interest is included in H's gross estate under Rule 2. Under Rule 3, this involves all other situations or cases. So in this illustration, well, let's talk a little bit about it first. Where there's any one tenant who has provided consideration for the acquisition of the jointly held property, you're going to fall under the consideration rule. And what is included in the decedent's gross estate, where consideration has been provided for the acquisition of the property, is going to be calculated by starting with the entire value of the property in the decedent's estate. Then we need to demonstrate how others provided consideration for the acquisition of the property. So the simple rule is that you include the fractional share of the value of the entire property based on the decedent's proportionate share of the consideration provided, assuming we can show the amount of consideration provided by the other joint tenants. If you can't show that the other joint tenants provided consideration, then the entire value is included in the decedent's gross estate. So the burden of proof will need to be overcome. As far as the nature of what is included under Section 2040A, it again applies to joint tenancies, tenancy by entirety, or joint bank accounts where the surviving bank account holders have a survivorship interest. So a husband or wife cannot dispose of their undivided interest unilaterally in their lifetime. Some states do not recognize tenancy by the entirety as a form of ownership, and that occurs in California. And in California, it would most likely be treated as a joint tenancy. So we're not talking about other forms of concurrent ownership such as tenancy in common. And that's because as a tenant in common, the interest is included under Section 2033 and not under 2040. And that's because with joint tenancy, your undivided interest goes to the survivor. Just because it doesn't apply under, say, Section 2040, it doesn't mean it will not apply to another code section. So the key to the key to the need for this particular statute under 2040 is the right of survivorship. If we didn't have a rule that included property held in joint tenancy in the gross estate, we would find that Section 2033 doesn't reach that property interest because it does not, it's not controlled through the decedent's will at death. So the statute under Section 2040 is needed because it pulls in the portion of the property you own into the gross estate at death. Further, because of how the statute is written, there can't be any discounts. There's no way around it. Whether or not a property interest in question is a joint tenancy or held in some other form of concurrent ownership is based on state law, and we've discussed that in detail in our discussions and problems in the past. So now we'll move on to this next illustration. And in this situation, if we have property that's been held as community property, a discount is allowed if it's held by husband and wife. And that's because H can give his interest to whomever he chooses at his death. So a discount can be given on H's interest when he dies at his death, and the inclusion rule for the community property is under Code Section 2033, while joint tenancy's inclusion rule is under Section 2040. Now, if you have community property that's used to purchase joint tenancy, well, in California at least, if you die testate, which is with a will, then the form of title prevails, meaning it would be treated as joint tenancy and the interest is included under Section 2040. If you die intestate, it'll be treated as community property, which means that 1/2 of the interest is going to be included under Section 2033. Again, in California, we have property that can be held as community property with rights of survivorship, which is not joint tenancy. And it appears to be includable under Section 2033, but certainly not includable under Section 2040. So unsecured creditors of the decedent can reach the portion that is community property, but not the portion that's joint tenancy property. And we went through a lot of that in our discussions in a number of the past sessions. Again, what that means is that community property is not the same as joint tenancy because creditors can reach community property. And one final point on title: if property is held in joint tenancy, but prior to death it was turned into tenancy in common, in this case, how it's titled at death is how it's going to be treated. So it would be held, if it's held as joint tenancy in common, it's going to be governed by Section 2033. In this next illustration, we can demonstrate Section 2040A with this example. And here we have A, B, and C who receive the property by gift from grantor G. If A dies in this case, A's 1/3 interest is included with no discount. Basically, since it's received by gift, you include 1/3 of that property. But remember, under Code Section 2040, there is no wiggle room for a discount, and this has been litigated. In the next example, we're going to look at a situation when there's been consideration given. So if we have A, B, and C who acquired the property together, and A gave 25% of consideration between them and the others provided the other 75%. When A dies, 25% of the entire property is included, and there is no discount again that's allowed. And on our final example, if you have a spousal joint tenancy between H and W, husband and wife, and if H dies, per Code Section 2040, 1/2 of the property value is included in H's gross estate. And that's, 1/2 again of the entire property. And in this case, the amount of consideration is not factored in. It should also be noted that Section 2040B doesn't apply to a situation where there's joint tenancies created before 1977. It also does not apply if the surviving spouse is not a U.S. citizen. It has nothing to do with when the joint tenancy was created with respect to the citizenship. Section 2056 D1B tells you that Section 2040B does not apply when the spouse is not a U.S. citizen. If Section 2040B is not applicable, you're going to go to Section 2040A. So it will be a circumstantial thing relating to how they acquired the property. Finally, when we are measuring the amount of consideration provided by someone other than the decedent, to the extent that the consideration they provided was received from the decedent for less than full and adequate consideration, then it does not count as consideration provided by that other party. And in that case, it's considered as consideration provided by the decedent. So you went through the tracing of consideration in your problems, and hopefully this all makes sense. And we'll talk again on the next video.